financials will go to a lien. That case will run coterminously and concurrently with 18-2282. In that case, he'll be adjudicated guilty, revoked, and terminated his probation, a $100 VOP fee, 11 months, 29 days in the county jail with credit for time served. I'm showing 213 days credit on 18-2282.
Okay, we're not agreeing. There's not a specific agree. Is there a specific agreement as to the credit? Normally, we don't do that, so I just want to make sure if we're.
We normally just announce credit for time served.
I know, but you said the number.
For the benefit of Mr.
I don't want that number to be out there and then it be a day or two different and all of a sudden.
I understand.
That's what I'm just trying to clarify.
Credit for all time served.
Okay. So we think that's approximately what it is, but they have to calculate. We don't actually have the actual calculation on how to do that. So we want to be very precise so you understand what you're doing. So I'm going to be asking you some questions about it. Okay, go ahead, Mr. Dees.
Judge, in the new case, it's 22-426. Count one, he'll plead to a lesser included offense of possession of a controlled substance. The recommendation, that is an F3, L3, maximum sentence, 5 years, $5,000 fine. The agreement on that one is an adjudication of guilt, 11 months, 29 days in the county jail with credit for time served, be a $515 fines and costs. That will also run concurrently and coterminously with 18-228, which is the VOP. Count two, he'll plead as charged, 11 months, 29 days in the county jail, credit for time served, $515 fines and court costs. That will run concurrently and coterminously again with 18-2282. Count three of 22-426, as charged, adjudicate 11 months, 29 days county jail, concurrent and coterminously with 18-2282. And count four the same, as charged, adjudicate credit for time served to run concurrently and coterminously with 18-2282. I believe that is the entire agreement, Judge. No objection to the score sheet.
So not to boil it down, oversimplify it, but all these are being concurrent and coterminous at 1129. So we're basically dealing with an 1129 sentence, right?
That's it, Judge.
That's correct, Judge.
Okay. Very good. Is that the state's agreement?
It is, Your Honor.
Okay. Mr. Perry, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Just want to make sure, ask you a couple questions, make sure you understand. It's free, you're freely and voluntarily entering into this. Obviously, there's some jail time involved here. Just want to make sure you're clear about it. So you heard your attorney state the terms of the plea agreement, both the violation of probation and the new law charges. And essentially, and they're all being served concurrent and coterminous. In other words, they're not stacked on top of one another. Basically, all these are being served at the same time. 1129, county jail, credit for time served. You understand that?
Yes, sir.
Okay. And have you had a chance to go over with your attorney all of the legal ramifications of this? Because obviously this affects your records, not just the 1129. It affects your record. That may affect something. Have you had a chance to go over all that with him? And you understand that by entering into this plea agreement, you're waiving the right to go to a trial. This is the final adjudication of all these. You understand that?
Yes, sir.
Okay. Do you have any legal questions? Have you had good representation on this? You satisfied with this?
Yes, sir.
Okay. Is there a legal basis for the entry of this? Not only legal, but a factual basis for the entry of this plea here today?
Yes, sir.
Okay, very good. Based upon that, the court will accept your plea agreement. One last thing, Mr. Dees.
Yes, Your Honor.
I assume you are, I don't want to assume, but I should ask you, the score sheet, you're in agreement?
Yes, sir. No objection.
Very good. Based upon this, the court will accept these plea agreements on both the violation, probation, and new law charge as set forth specifically and in the plea and sentencing agreements, which I see you've signed, right? You went over those with your attorney?
Yes, sir.
And the court will sentence you to the 1129 as specifically set forth, as well as the other details that are contained in this plea and sentencing agreement. Any questions? Okay. Thank you very much.
Thank you.
Judge, I'll pass Mr. Moore, and I'll be right back. Thank you.
Okay. Allison Jimerson.
Your Honor, if we can keep her here, but put that on for a little bit later, we're having to make some modifications to the plea agreement.
Okay. So we want to pass over okay.
Just for...
Just for a couple minutes, we need to
Yes,
pass
Your Honor.
over this. All lemon? Mr.
In
Noakes?
my case, I'm almost got it worked out.
Okay. Holquin, Timothy Holquin. That's, I know Mr. LaPella had a trial going on. What are we doing on this one?
Your Honor, I believe that was already moved. Let me check.
I know he moved some, and this might have been the one that was continued. I know the other one we continued it.
Looks like that's been continued.
Okay, so it's continued to June 15th. Okay. And Janice Porter, also, that's continued actually till 6/8/22. That's a little more complex, and there's a case management conference status on 6/13 at 11:30 a.m. That was coordinated with both offices based upon Mr. LaPella having a jury trial that I think they're picking a jury as we speak. So, I believe that's right. Isn't that what your understanding is? It was off schedule. It was off I can pull my calendar. I think it was next Tuesday. Is it? Well, no. Don't change it.
Here and maybe not get a.
Okay. June 13th at 1:30? I've got 11:30.
Okay, 11:30, sorry.
Okay, June 13th, 11:30.
You're welcome.
Okay. I'm going to skip over Caleb Roach, just, you want to, or, well, we'll do it now. Caleb Roach. Or Roche, or maybe,
Caleb Roche. Charles Russell, Public Defender's Office, Judge. On the docket is case number 2019 CF 1488. Mr. Roche is also on the afternoon docket under case number 22 CF 1198. I don't know if you want to wait and see if he shows up.
let's wait until if you see, you may have misunderstood, so.
Okay, thank you, Judge.
Okay. Remind me of this afternoon, because it mixed me up. Jeffrey Gunter. Mr. Stewart, is Mr. Stewart here?
Your Honor, I believe there was a stipulated motion for continuance filed on 6/6. I just don't believe there was an order signed.
Okay.
I think his intention was to put that back on the pretrial docket.
We'll continue to 6/29 on the pretrial docket, okay? Your attorney filed a stipulated motion to continue until 6/29 on the pretrial, so apparently that was dealt with, so he's not here, but I didn't get a copy of it to get it signed.
I'm so confused too myself. All right, thank you, sir.
Okay, so we'll come back on 6/20, that's the regular pretrial docket.
That's
Okay.
fine with me, sir.
Okay, thank you. Anthony Roca. That's Brad Stewart's also.
I believe he filed to continue that one as well. I see that it's listed, that it was removed from the docket, that it was,
Okay.
or supposed to be removed from the docket. This is-
So when is it continued, just so we have a record? When was it?
This says the 15th.
Just June 15th? Okay. Very good. William Frazier. Would the state announce this is one? Just come forward to the podium, sir.
Your Honor, Mr. Frazier's before the court on 21 CF 2920. This is his,
So this is one of the
Violation
cases that
probation.
I mentioned to you before. You do have a right to an attorney with these matters. Do you wish to have an attorney appointed, or are you going to hire private counsel? Okay, so the court's going to go ahead and appoint the public defender. I'm going to enter a denial, so you don't give up any rights on this, and then we'll come back on the 30th?
That's fine, Your Honor.
Okay, so we'll come back on June 30th at 9 a.m.
Thank you, Judge.
Thank you.
Your Honor, just so the court knows, since Mr. Frazier has been out of jail and back on community control, he has stabilized with a residence, and he got him a job. So
Okay.
I just want the court to know that he's doing really well now as
Okay.
opposed to before.
Okay, good. Appreciate that update, Mr. Barry. Stacy Reeves. Miss, would the state announce?
Judge, Ms. Reeves is here for a VOP in 16 CF 1720.
Miss
Looks like
Reeves, you,
it's her first time up, Judge.
okay. Miss Reeves, you didn't hear my little initial statement at the beginning because you were in the back, but you do have a right to an attorney with these
Yes, sir.
type of cases. So first thing I need to do is ask you whether you wish to have an attorney appointed, or you're going to hire private counsel.
I'd like to have an attorney appointed if,
Hold on. So we're going to appoint the public defender. And generally, what we do in these cases, because it's your first time up, is go ahead and automatically enter a denial. That preserves all of your rights, so you have a chance to talk to your attorney before you,
Yes, sir.
take any further substantive action on it. So the
Thank you,
court's
Your
going to
Honor.
enter a denial, and we'll come back on June 30th.
And Judge, she does have an arraignment set for her new law violation on June 30th, and information has been filed, so we can either do it that day or we can go ahead and do it now if the court would like.
Could we put them both at 1:30?
Today?
Add this one to the 1:30 first.
Is that on today's?
The new law is not, Judge, it's just set for the 30th, so I brought it
You want
just
to
in
do both
case.
of them on the 30th?
Yes, sir, at 1:30.
Okay, very good. So we'll continue this at 1:30, Madam Clerk.
called 2 days ago.
These are felonies.
Yes, sir.
That's why
Anita Smith.
Thank you, Your Honor.
Thank you. Anita Smith.
This is no attorney.
The state announce and
Judge, this is 21 CF 2096. Ms. Smith's here for her first time VOP. Ms. Smith?
I'm going to try and save a step on this one. What's the state asking?
State's asked for a capias, Your Honor.
I'm going to go ahead and skip a step and go ahead and appoint the public defender, even though she's not here. If she doesn't accept it later, we'll deal with it, but at least allow you to have a chance to talk with her. We're going to go ahead and issue a capias.
Your Honor, I will contact your probation officer, see if he can get in touch with you.
Okay, thank you.
Judge, is that a no bond or a first appearance capias?
Lamarcus Tatum. Would the state announce, please?
Your Honor.
21 CF 2382. Mr. Tatum, this is a violation of probation, and you heard my little speech earlier. You do have a right to an attorney. You wish to have an attorney
Yes, sir.
appointed, or you're going to hire private counsel?
Won't want to appoint it.
Okay, so the court will appoint the public defender, and as I said before, I'm going to go ahead and enter a denial on your behalf so you don't lose any rights. We'll come back on June 30th at 9 a.m. Just make sure and stay in contact with your attorney. Okay, thank you.
Still gonna do that.
This case, Your Honor?
On this case. Okay, we're just going to pass over this so you have a chance to chat with your attorney just for a second. Barbara Abrams?
Casey Etheridge for Barbara Abrams. I'm assuming she's coming.
Yes.
And we had something worked out and then something came up, so we'll say. And so we're asking to pass this case so we can,
You know, pass this
there's another new case.
Okay.
So,
So, you want to pass it today, in other words, come back today, or come back on another
probably
day?
come back on another date.
Okay. You want to come back on a miscellaneous day, or?
Yeah, can we do June 30th? Your Honor?
Okay, that's fine. So,
What date on the 17th?
Yeah.
And this is 7th.
we'll come back on June 30th at 9 a.m.
I understand.
Jake Bell? And the Abrams case was 22 CF 210, just for the court record.
Casey Etheridge for Jake Bell. This is 2021 CF 2377.
6 months ago.
It revokes and terminates your probation. Yep. Yep. Yep.
What happened to restatement?
She's not going to reinstate you. What do you want to do? You want time to think about it? Can we pass him, Your Honor? And I'll bring him back later this afternoon, or not later this afternoon, but later this morning, if you don't mind.
Later this morning.
Thank you.
Tina Blackwell.
Okay, go ahead, and I'll come back and see you. Casey Etheridge for Tina Blackwell. We're here in 2017 CF 439, 2017 CF 2435, and 2017 CF 2736. So you got it. They won't tell me until you get it released.
If I don't know what I got in, gotta be stupid.
Okay, well, it means you're going to have to find out. Right, well, that's how it is, yeah. I mean, you know how long you've been in or not, so that's how. Yeah. I mean, from.
Or can I just
the
plead out to the
arrest.
judge?
You can,
Yeah,
okay, but, okay.
I got time, man. Can I speak to him?
She would like to plead to the court, Your Honor. I don't know how the court does that. I haven't had that here yet in Okaloosa, but.
She wants to plead the court, Your Honor, I just as we said. Prepare.
I mean, cause I got
Take a
time,
plea
man.
today, and then we can send it on the 15th.
I mean, cause I got time in on these cases. Like, it's dating back to 2017. I done did time on these. I'm just trying to.
Blackwell, don't say, I don't want you to jeopardize your case. So you do have a right to plead to the court. And then we'll come back and obviously, you'll have legal representation to argue about the sentence. The state
I just ain't gonna
We'll
take it.
come back
I
and-
just don't wanna take it. See if they go lower.
Okay.
I'll tell you what, why don't we, I think we need to come back because we need to have a plea agreement well, do we know, I would think we would put this in writing because I want to make sure she understands what her maximums are, make sure she's reviewed the score sheet, what all this means. Main thing is, whenever you enter into a plea, ma'am, what's important is that you understand it's voluntary and you understand what you're doing, okay? Don't want you just stumble, hey, I want to do this, and then later you go, well, I didn't realize that, okay? Because these have significant consequences for you, right?
Yes, sir.
And I want to make sure you do it voluntarily with understanding. And usually that means after going over it in some detail with your attorney. That's an important component of that because I'm assuming you're not a trained lawyer. I'm saying is she's
Oh,
a
me?
trained lawyer, yeah. So you're not a trained lawyer, she's a trained lawyer. She can make sure she explains certain things to you. So you have a right, that's fundamental right you have to get that legal representation. Make sure you don't just get railroaded.
Yeah.
Keep your arm twisted. That's not what we're trying to do here. We want to make sure
Yeah,
everybody's
that's
clear
what-
about what we're doing. So we'll
that's
come back,
ridiculous.
let's come back on the 15th and we'll go from there. Okay.
Thank you, Your
We'll
Honor.
come back on June 15th.
Will that be at 1:30, Judge?
Yes, let's go ahead and do that at 1:30. And that'll be for a plea and sentencing. What do they have in the morning?
There's only 15.
Okay, why don't we, let's do later in the morning. Let's say 11 o'clock in the morning.
Okay.
So we'll just do it. Hopefully we'll get the other ones done. Would the defense and state approach real quick? You ready, Mr. Nopes?
I'm ready, Judge.
Okay. Let's double back on Paul Lemon.
Judge, if I may approach.
You may. Thank you.
Judge, on behalf of Marty Nopes, on behalf of Paul Michael Lemon, case number 2020 CF 3171. Judge, he's going to admit the violation of probation with the understanding with the state. The adjudication would be withheld. There'd be a $100 VOP fee, and the probation would be modified to 1-year drug offender probation with 7 p.m. to 7 a.m. curfew.
11 to 7?
11 p.m., I'm sorry, to 7 a.m., sorry.
This is a downward departure, right?
Yes, Your Honor.
15.1, that's what I've got here on the score sheet. I'm just looking at the score sheet.
Yes, Your Honor.
And that is based upon
This was a agreed upon
negotiated plea.
negotiated plea.
Okay. Very good. Anything else on yours, Mr. Nopes? Okay. So is that the agreement?
Yes, Your Honor.
And the defense is in agreement on the score sheet? Did you look at that? Okay.
Yes, sir.
So, Mr. Lemon, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God? Okay, you heard the terms of the plea agreement. Now, one thing I want you to understand, this is, you're getting, the probation is modified to a 1-year drug offender probation with a curfew. So there's some additional conditions. That all sounds well and good. There's one thing you need to understand, and that is your max. You know what the maximum sentence is on here?
15 years, sir.
Okay. What I'm saying to you is, I'm going to ask you whether it's free and voluntary and you understand what you're doing, but I understand why you're entering this plea. It's a good plea agreement for you, right?
Yes. it
Okay.
is.
You need to you got to have some, I'm committed to this, because if you come back and it's a violation on this, you're really subject to some serious.
I
Do you understand that from a kind of a legal stance? Make sure and go over that with your attorney?
Yes, I do, Your Honor.
Okay. And you're entering this free and voluntarily? You've
Yes.
gone over the plea and sentencing agreement? A lot of details in here. Have you gone over that with your attorney? I see you've signed the end of it?
Yes, sir.
Okay. And you understand that by entering this plea, that you're waiving the right to go to a trial. This is a final adjudication of this violation of probation.
Yes, I do.
Okay. And you've had all your questions answered from your attorney?
Yes, sir.
Okay. Very good. Anything else from the state?
No, Your Honor.
Based upon that, the court will accept your plea of an admission of the VOP, continue to withhold adjudication. Probation will be modified to a 1-year drug offender probation, 11 p.m. to 11 a.m. curfew. Okay.
p.m. to 7 p.m.
11 p.m. to 7 a.m.
I know, I said it wrong too, Judge. I mean, it's just our mind.
11 p.m. to 7 a.m., right?
Yeah, absolutely.
Okay, at night.
Right, at night,
Okay.
right.
Okay, very good. Okay,
Thank you, Judge.
Good luck with it.
Thank you.
Your Honor, from
Yeah.
a probation standpoint, if he, for some reason, gets a job and has to leave before 7 a.m., we would ask that probation be allowed to adjust that curfew without having to come back to the court.
I assume there's no objection to that. Without objection, the court will agree to that. Thank you.
Thank you.
Thank you, Judge.
Okay. And that's all you got today, Mr. Nopes?
That's all I've got, Judge. Thank you.
Okay, thank you. Have a good day.
Ray, I can come back.
Come on. You may. You want to do Jimerson?
Yes, please.
Your Honor, the state's going to have to redo the score sheet, so I will submit it later. Give a copy to counsel and file it with the court.
Okay. You have a copy of the plea agreement, so I can...
Do we have to redo it this
You only have
morning?
one? Okay, that's all right. Just go over it slow, because I want to make sure I follow it.
Yes, Your Honor. I'm ready now, Your Honor. Thank you for the delay. Michael Gilbert on behalf of Allison Jimerson in 22 CF 030 and in 22 CF 509. We have come to an agreement with the state. At this time, we'd like to withdraw offer of not guilty and plead no contest to 22 CF 030, and plead to a lesser included offense of burglary of an occupied dwelling, as well as misdemeanor simple battery. 6 months OCJ, credit for time served, 3 years probation, no contact with the victim BM, no threats or acts of violence. She'll take anger management, mental health evaluation, and any recommended treatment. Restitution of $2,807.70 to be paid to the victim at a rate of $100 a month starting no later than 60 days from now. Court costs of $767 and cost of prosecution of $100. On 22 CF 509, as charged, and 6 months OCJ with credit for time served, 3 years probation, no contact with the victim, no acts or threats of violence, anger management and mental health evaluation and treatment. Court costs of $415, cost of prosecution $100, cost of transportation $166.33, all concurrent with 22 CF 030. May I approach, Your Honor?
You may. Thank you. Thank you. Ms. Jimerson, would you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Okay. One thing I want to be clear about because you said two different things as far as the mental health evaluation. You said anger management and mental health evaluation.
Anger.
Is that?
Two separate things, Your Honor.
Okay.
She's to complete the traditional anger management treatment. She's also to have an additional mental health evaluation, and if they decide...
Follow anything?
Yes.
Okay, so it's not an anger management evaluation, it's actual, she's going to take that program?
Yes, and then she will also have...
She'll evaluate the other. Do you understand that?
I do.
Okay. So that's an important part of this. That's, if you will, the positive part of this. And obviously, nobody wants to be in your situation, and I wouldn't say it's positive, but it might be positive if some of these things can be dealt with, because you don't want to be back here in an orange suit, right? Okay. So you heard your attorney state the terms of the plea agreement, and I see that those terms are the same that are on the plea and sentencing agreement. So have you gone over those terms and this plea and sentencing agreement with your attorney?
Yes, I have, Your Honor.
And okay. You have her sign the back of this. You had her sign one place, but you have to sign the other one. I was going to ask you if you signed the plea and sentencing agreement, and I realized you hadn't. You signed one of it, but the other one.
Third edition.
Your Honor, at this time, we orally amend, and so she'll be pleading to the lesser included battery of an occupied dwelling, and we will add the count of misdemeanor battery.
Okay, very good. Okay, did you hear that?
Yes,
And that's
sir.
the same thing your attorney said. You're in agreement with that. So have you had a chance to go over this with your attorney, make sure you understand all the legal ramifications of this? Because you're entering a no contest plea, but that's kind of like a half-brother to a guilty plea, and it has an effect on your record as well as the time in the Okaloosa County Jail that you're agreeing to. And this is 60 days. You'll get credit for, let's see, make sure I'm having a hard time reading your writing.
It's
Yes,
6
sir.
months, Your Honor, with credit for 6 months served,
Okay, she's already been in 6 months?
with the credit time served that they give per month, yes, sir.
So technically what you're getting is 6 months, but you always get credit for time served. They're just saying informally, it's not part of the plea agreement. You've already been in there 6 months, so I'm sure you know that.
Yes, sir.
So, but I just want to make sure. So you've gone over all these things as far as the as the fees and cost and the restitution, gone over all that, and you're
Yes, Your Honor.
willing to abide by that? And that's, all those are, the restitution is starting with the monthly payments starting in 60 days? Is that, okay. And you've got not only the 6 months, but also the 3 years of probation. That's in addition to that, correct?
Correct.
Okay, so you understand that. So when you get out, you have to make sure and follow up with the evaluations and make sure, that's really what they're doing in that probation period. A big part of that is making sure you follow up on that other stuff,
Yes, Your Honor.
so that hopefully this will end up being a little more positive. So you understand that by entering this plea agreement, you are waiving the right to go to a trial. This will be a final adjudication of all these items. You understand that?
I understand.
Okay, very good. Based upon that, the court will accept the plea, and the sentence will be the 6 months. The core is the 6 months in the county jail, credit for time served, plus 3 years of probation, along with the other conditions, the important ones, of course, being the evaluations, et cetera, that are a part of this. Do you understand that?
Understand that.
Okay, very good. And we'll wait and sign the score sheet, if you'll just make sure and review that so that you can be in agreement on that. Okay, very good. Thank you very much. Hold on a second, ma'am.
Can I get that a total on restitution again? 28?
It's 2807.
2,807.70.
Who is that to?
That is to the victim, which is Brandy Madden. She used to have no contact with Brandy Madden.
Ms. Jefferson, again, just by point, I'm not trying to kind of pound away at this, but I want to make sure that, you know, you have the best chance of being successful on this. No contact is on you, okay? So that means even if, I don't know the situation, she approaches you, she calls you, you're in violation. So you need to make sure that you make the objective to stay away, and if there's contact, you need to talk to your pro, if she's contacting you, whatever. I'm just saying, it's on you to stay away from her, not vice versa. Okay, do you understand that?
Yes, sir.
Okay. Question?
And Your Honor, since she has to pay restitution in the amount of $100 a month, we ask the supervision fees be waived.
So ordered.
And would the court prefer her to get the mental health evaluation done first before she gets into the anger management?
Is that the general preferred way to?
The treatment facility would prefer us to send them to one and then go to the other one instead of trying to do them both at the same time, unless they can incorporate them both.
I think probably the most important thing is to get the mental health eval, and so you can make sure and get that good and solid.
We'll refer her to that first. Thank you, Your Honor.
Okay.
Thank you, Your Honor, that's all I have.
So, Mr. Dees, is he finished with his? He's still working on it? Okay. All right. Merton Braley.
Yes, Ridge for Mr. Braley, we're here in 2021 CF 2073. What do you want to do? Okay. Okay. Sure. Here, I need you to sign that. One moment, Your Honor, he's signing it.
Thank you. Want to go ahead and explain the plea agreement?
Yeah, sure. So, Mr. Brayley, we claimed two second-degree misdemeanors, that's why there's no score sheet, and it would be adjudication of guilt, 60 days county jail with credit for time served, $300 court costs, $100 cost of prosecution, $150 public defender fees, and count two's credit for time served as well. I believe that's everything.
Okay. Mr. Brayley, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, and nothing but the truth, so help you God?
Yes, sir, I do.
You just heard your attorney state the terms of your plea agreement. Is that your understanding of what the plea agreement is? Okay, and I see that those same, the plea agreement is in writing on the plea and sentencing agreement. I see that you've signed the back of it. Have you gone over this plea agreement with your attorney? Just make sure you understand all the ins and outs, the legal ramifications.
Yes, sir.
Do you have any questions?
No, sir, not the plea agreement itself, sir.
Okay. Do you have any other questions?
Yes, sir, I would like to, I had a felony charge that this has got dropped. It was an antique.
Are we talking about another charge? Help me out, counsel. What are we doing?
No,
What's on
the
the charge?
original charge was possession of a firearm by a convicted felon. There's a portion of the statute that says if it is an antique firearm, it gives the parameters that it in fact is not possession of a firearm by a convicted felon. And Ms. Etheridge was able to prove that it was in fact an antique firearm.
Okay.
Therefore, we changed the
I
charge.
mean, I didn't use it in the commission of a crime, so there ain't no law that says that I can't collect them. I mean, there's a family here to them, you know. I was just transporting them from one place to another. So, with that being that, I was wondering if I could get my granddad's stuff back. I mean, I need a lease order.
So does that need to be a,
The defense will have to do a separate order for the court to sign to release it.
you're not
No.
not objecting
No, Your
based
Honor.
upon the fact that,
The statute's clear, so.
okay.
And I also got another complaint, is, in the process of all this, this was the only charge that had a bond on it. The other charges that I have was signature bonds for like traffic citations and stuff like that. This is the only thing that held me in jail for 10 months. 10 months straight, I stayed in jail for this charge right here. This was a false accusation towards me. I didn't do nothing. I was just simply driving. Yeah, I might have drove down the road without no driver's license. I was gonna go get me something to eat and some clothes and wash down at my uncle's and them's house.
The state would like to respond. That was a good faith charge by the police. There was no mention the fact that it was an antique firearm, and Ms. Etheridge had to go through considerable trouble to prove that. It's not something that was readily apparent.
Well, you know,
What I'm saying is in the process of me moving, because I was being evicted and stuff like that, and I was going down to my uncle's house, my vehicle went to a towing yard, and I stayed 10 months in the county jail on a charge that didn't even exist, for real. And now I don't have nothing. Everything I own is gone.
well,
Was there any, do you see any justice in that, Your Honor? I mean, honestly.
well,
I'm not saying it's no individual ones, it's just the system itself, you know,
well, actually, there were some crimes involved with this,
I mean,
and those were settled. However, the one thing I will say to you is first of all, the system worked, i.e. the charge was dropped and we got it right. The one thing that I and everybody in this courtroom is trying to do a better job of, that's really not anybody's fault, but fault of the worst worldwide pandemic in 100 years, is we're trying to move our cases faster. And for that, it took 10 months to get this resolved. On behalf of the system, it's not what we want.
that's what it is. I'm glad to see that.
But we are where we're at with it, and we're trying to do the best we can with it. But I agree with you, wish we could go faster, and we're,
I mean, I ain't worried.
Trust me,
I
we're-
ain't worried about time, I'm talking about the rights behind it all. I have to
Well,
answer for,
you-
I have to answer for my do-wrongs, you know what I'm
That's
saying?
right. Well,
I mean, nobody else has to answer.
that's why you had an attorney, and that's why it got resolved. Okay? So, back to what I've got to do here as far as getting this plea agreement dealt with. You understand that by entering this plea agreement, you're waiving the right to go to any type of final hearing, this is the final resolution of this
I'm done with that
case?
charge, yeah.
Okay.
I'm good with that.
Okay, very good. Based upon that, the court will accept your plea on the lesser included charges and sentence to the 60 days, credit for time served, as well as the fines on the reduced charges. Very good. Good luck. Thank you.
Let's go.
Hobart Burbank. Oh, hold on. Ms. Flowers, are you ready? I saw you, yeah, we can do yours. This is your only case. Mr. Dees, are you ready to go too? Yes, Your Honor. Okay, we'll get y'all's.
Your Honor, approaching Ms. Heather Heiger, Jennifer Flowers. On behalf of Ms. Heather Heiger in 2013 CF 1808, she's here on a violation of probation today. We've reached an agreement with the state. Would you like me to approach with the plea agreement and score
Please.
sheet? Yes.
Thank you. Got me, I'm trying to find it on the docket, we're out of.
Your Honor, that is my only copy, but I think from memory, I think.
No, you take it.
Are you
If you
sure?
want to do it, so I want to make sure,
Okay.
because we're putting it on the record, and I'm actually sentencing according to what you're.
Ms. Heicher here is going to admit the violation of probation today. It's a technical violation. The sentence agreed upon with the state is an adjudication of guilt, reinstate and modify her probation to 2 years of community control, and for her to successfully complete outpatient drug treatment at Bridgeway, $100 VOP fee or cost of prosecution fee, $150 cost of defense, and those will be payable during probation.
Would you approach?
Yes.
Is that the agreement with the state?
Yes, Your Honor.
Okay. Ms. Heitker, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
One question I have, just by point of clarification, so, because this is a part of this, we're modifying it to 2 years of community control, based upon what you're saying, is to successfully complete the outpatient drug treatment. Has there been an evaluation? That, to me, is, usually you evaluate and follow the recommendation.
No.
Is it intensive? I mean, do we know exactly what it is? Because you're qualifying, you're saying outpatient. So you're telling them what program to do. I just want to make sure we're clear about what it's, because I don't want anybody, well, I didn't realize that, and then, here we're looking at a violation or something. We want you to be successful. You understand my question?
Yes, Your Honor, I think the intention was for her to get an evaluation. I didn't word it in that way, but to get the evaluation and complete treatment at Bridgeway.
You understand what?
Rather than inpatient treatment at Keaton.
So we want to do an evaluation, okay? And we'll do it at Bridgeway, and that's fine. There are different levels that they have. So you're going to, what you're agreeing to, and I'm going to ask you to amend this here in just a
Yes, Your Honor.
second. What you're agreeing to, I want to make sure you're agreeing to, I'm not telling you you are, I'm asking you. You're agreeing to get evaluated and follow their direction, whatever it is.
Yes,
Is that your understanding of what you're agreeing to?
Yes, sir.
Okay, and you're comfortable with that?
Yes, sir.
Okay. Let's see. Okay. And you understand that by entering this plea agreement here today, you're waiving the right to go to a trial, and this is the final adjudication.
Yes, sir.
And have you had a chance to go over this plea agreement, and because there's a lot of details in there, with your attorney, make sure you understand what this all means to you legally?
Yes, sir.
Okay. And obviously, we're going to reinstate with 2 years of community control. Higher level of involvement, you understand that? You're
Yes,
willing to
sir.
do that? You understand, probation, community control, you know what the next step is, right?
Back to prison.
Right. That's not where we want you to go. I'm telling you that, I'm not trying to I'm just saying, take this seriously, stay in real good contact with your probation officer. That's probably the most important thing. It sounds silly, but it's really the most important thing, because they're the ones that can work with you if there's some issue that comes up, okay?
Yes,
So-
sir. Evaluation.
Go out of your way to stay in good contact with them, even if it's, don't make them chase you down. Okay?
Yes, sir.
You understand that? Okay, so is this defense in agreement on the score sheet?
Yes, Your Honor.
And so this is a downward departure?
Your Honor, I don't believe, since it's a modification of probation, we don't have to, the court doesn't have to find a downward departure.
Okay. Very good.
We also added to the plea form, the plea agreement, that all of the original terms and conditions of probation will also be reimposed.
Okay. And the court will waive the cost of supervision.
Your Honor, just so Heather, I can't pronounce her last
Hi,
name,
Heather.
understands, the next 2 years on community control, followed by the remaining period on supervision, correct?
That's my understanding
Yes,
of
Your
what...
Honor.
Right,
Okay.
I'll be explaining that to her.
Yes.
Okay, very
She
good.
understands.
Okay, you can come forward. Yeah, thank you. Okay, very good. So based upon this testimony, Ms. Heitker, court will accept your plea agreement. There'll be an adjudication of guilt, reinstated and modified to 2 years of community control, as well as the other costs and fees and the evaluation that is contained in the plea agreement. Okay? Very good. Any questions?
No, sir.
Okay, good luck.
Your Honor, I have 2 other cases on the docket.
Okay.
May we take those?
Sure.
Okay. They're both
What
incarcerated.
numbers are they? Where are they?
I'm not sure what number they are on the docket. I have Crystal Nelson. She's,
Hold on, let me find it. Oh, really? Okay. Go ahead. Are they here, or are they in?
yes, they're in custody.
So why don't you just announce the first one, so I
Yes,
got it right?
Jennifer Flowers on behalf of Crystal Lynn Nelson in 4622 CF
Okay,
1.
so, slow down on the case number.
4622 CF 1018 and 4622 CF 1360.
Thank you. I did not get the add-on, but it'd probably be miscommunication on our part. I leaned out. I just got back yesterday.
And I do have 2 copies of this, so I can
Great,
approach it.
thank you. And is the defense in agreement on the score sheet?
Yes, Your Honor.
You just have one bucket.
Ms. Nelson is here today, Your Honor. She's prepared to, on 22 CF 1018, she's going to withdraw her previously entered plea of not guilty and enter a plea of no contest. And 22 CF 1360, she's going to enter a plea of no contest and waive arraignment. She's not been arraigned on those charges yet. And the agreed-upon sentence will be as follows. As I stated, she'll plead no contest as charged in 22 CF 1018. She'll plea as charged to count 1 and 2, adjudicate guilty, credit for time served, $615 in court costs, $100 cost of prosecution, and a $150 cost of defense. And 22 CF 1360, count 1, she's going to enter a plea to a lesser included misdemeanor, driving while license suspended or revoked, adjudicate guilty, credit for time served. And on count 2, she'll plea as charged to possession of controlled substance, adjudicate guilty, credit for time served, $615 court costs, $100 cost of prosecution, and $150 cost of defense. And those costs will be payable would the court allow 160 days for her to pay those costs? State.
Yes. Okay, Ms. Nelson, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God? Is that the agreement with the state?
It is, Your Honor.
Okay. So, Ms. Nelson, you heard your attorney state the terms of the plea agreement, and I see that those terms are also written on the plea and sentencing written agreement that you have, I'll make sure, you signed. Have you gone over this plea and sentencing agreement and the terms of it with your attorney to make sure you understand all the legal ramifications? And are you in agreement with that? And are you entering this freely and voluntarily? Is it it is free, okay. That's what I said, is it voluntary?
Yes, sir.
Freely and voluntarily.
Okay, yes, sir.
Same thing. So, and you understand that by entering this plea agreement, you're waiving the right to go to a trial. This will be a final adjudication of all these matters. Do you understand that?
Yes, sir.
Okay. Very good. And the credit for time served, this will be an adjudication of guilt, which is contained in here. Do you understand that? If you feel like you've been well represented by your attorney on this matter?
Yes, sir.
Okay. Very good. Based upon that, the court will accept your plea agreement, and you will get adjudication of guilt, credit for time served. The cost and fees will be payable in 150 days, and again, you will get credit for time served. The one charge will be for the lesser included. Would you just add on here, payable in 150 days? Okay. Thank you very much, ma'am. Good luck.
And Your Honor, next I have on the docket Mr. Rico Jermaine Williams, case number 4621 CF 2219. Your Honor, I had placed Mr. Williams on the docket because I thought we had an agreement with the state, and we still do, but it looks like we need to wait and pass him and put him on the 15th. I would request to put him on the docket for the 15th to enter his plea.
Very good. June 15th at 9 a.m. We'll continue. Okay.
And that's all I have before the court, Your Honor, may be excused. Thank you.
Mr. Dees, you want to handle yours? You want to start with Moore?
He's my remaining client, Your Honor. This is Anthony Moore. He's before the court in violation of probation in 20 CF 362. He has reached an agreement with the state. Your Honor, may I approach?
May.
The score sheet. Your Honor, at this time, he is going to admit the violation of probation in 20 CF 362. The recommendation calls for an adjudication of guilt, revoke and terminate his probation, be an additional $100 VOP fee, be 4 months or 120 days Okaloosa County Jail with credit for time served on the VOP only.
Okay. I want to ask a silly question. Is there a difference between 4 months and 120 days?
No, I just wanted to make sure I realized when I brought it up there. I know Escambia County sometimes would prefer it in days, and I was getting my counties crossed, so I just wanted to cover my base, 120 days or 4 months.
probably would be better to put 120 days. So I'm going to ask you to change in just a second, but let me go through the colloquy first. Mr. Moore, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, and nothing but the truth, so help you God? Is the state in agreement on this?
Yes, Your Honor.
Okay. So you heard your attorney state the terms of your plea and sentencing agreement,
Sir.
the core of which an adjudication of guilt, revoke and terminate probation, so you're finished with that. 120 days in the Okaloosa County Jail. You will get credit for time served. And there'll be a $100 VOP fee. That's the terms of your plea agreement. Is that your understanding of what it is?
Yes, sir.
And I see that you've signed the plea and sentencing agreement that has those same things. Have you gone over all this with your attorney? Make sure you understand
Yes, sir.
what this all means legally to you?
I know what it means.
The impact that it means? You had all your questions answered.
Yes, sir.
You understand that by entering this plea agreement, you're waiving the right to go to a trial, and this will be a final adjudication of
Yes,
this.
sir.
Is that what you want to do here today?
Yes, sir.
Okay.
Like me to modify that, Your Honor?
And Mr. Dees, you're in agreement on the plea and the score sheet?
I am, Your Honor. No objection.
Very good. Based upon that, the court will accept the plea agreement and sentence you to the 120 days. You will get credit for all time served.
Thank you.
Okay? Thank you.
And Judge, just to clarify on the record, the credit time served is only for this VOP.
Is that correct, Mr. Dees?
That's correct,
Do you
Judge.
understand that? You
That's
understand that? Go ahead, go back. It's a good, we'll make sure and clarify that, as that was on there.
Yes, sir. Just VOP on. Yes. Yes,
Okay,
sir.
so credit for time served will be only for the VOP.
Okay.
Okay,
Very well.
okay.
Thanks, buddy.
Thank you.
Thank you, Judge.
Thank you. Is that your last case, Mr. Dees? Yes, sir. Okay, have a great day. Thank you. Tobert Burbank.
Casey Etheridge for Mr. Burbank, I'm sorry, I can't read today, 2022 CF 42. He offers 11 months, 29 days in county jail.
This is my first violation.
11/29.
Do about this.
Okay. Those are all options.
This is my first time I even violated.
Your,
I don't know what to do.
I know, anyway. Could we set this, Your Honor, for the? I guess we need to set this for a contested hearing, Your Honor.
Okay.
Please straight up to the judge.
Well, what can I do for, excuse me, Your Honor? I mean, what can I do? This was the first time I was actually violated and.
Don't argue. We're not here to argue. We're just here, this is a procedural hearing. I don't want you to get into the substance of it. You have a right to go to a hearing if you don't want to accept the state's agreement. The deal with a plea agreement is it's an agreement. We don't have to agree. That's why we have trials. You have a right to go to a trial. You got an experienced attorney. If you don't feel like they're giving you the right thing, then go to a trial. And then we'll deal with it. I'm not trying to be flippant about it. I'm not. I can't engage in the plea agreement. That's not my role. I'm the umpire only. I'm not engaged in the game. Okay?
So would you like a contested hearing, or we can plead to the judge? Those are your two options.
Say again.
So you can either have a contested hearing, or you can plead to the judge, whichever you would like to do.
How do I plead to the judge?
we'll have to do a plea agreement. I think the judge, for a VOP, you would still like a plea agreement, right?
Yes, absolutely.
Okay.
How do I plead to do that?
So we're gonna have to write up a plea agreement, and then I would bring it to you to sign, and then we'll do that.
So why don't we just pass over this, come back on June 15th, get a chance to really try and go over it with you, so you want to make sure you understand what all your options are. And if we have to go to a hearing, if you want to come to a plea agreement, we'll come back. Let's just come back on June 15th at this point, in the morning,
And we'll talk about, and you can decide which
without
one.
subpoenas.
So be
Okay.
thinking about it, and then come see you.
Okay, thank you.
Tell you what, let's take just very short, just mid-morning break. We haven't had a chance to do that. Literally 5 or 10 minutes. We'll be back. We'll finish up this morning.
All rise, please.
I have an audit date this afternoon. I have a case where how much
wouldn't say 2 months, you know, we're gonna be having like tons of contested hearings.
Yeah, he doesn't have much in the way of priors. You can do 6.
Okay.
Sheet, whatever.
Okay. So the offer is 180 days. This is wrong. She just changed it.
Maybe asking you some questions, kind of be aware of that.
And it would revoke and terminate your probation. Huh? No. Reinstate. Casey Etheridge for Ms. Campbell, and we're here in 2019 CF 1727.
Vince?
Yeah, no, of this month, next week.
You
You
need
said
more
this for
time,
the
we can come
15th
back
or-
on the 15th, that's
Yes,
not a
Ron,
problem,
that's
don't try and press it. June 15th, at 9 a.m. Robert Cannon.
I'll come see you and talk about it, see what you want to do. Casey Etheridge for Robert Cannon. May I pass this and recall him, like today?
Sure.
Thank you.
Dylan Diskowski.
No, because it's absconder, so no, it'd have to be county jail.
$180 days, 180 days today.
Whenever, whenever I got sentenced in Santa Rosa, the judge said he wouldn't have an issue with me doing it. And I tried to put in for the
You're not
serve
gonna,
it.
yeah, I'm gonna get it from them. You want a minute and I can come talk to you in the back? Is that what you want? You need a second?
If we don't have a deal, if you're welcome to continue to discuss it, we don't have to press it. Either we can
Well, I
do
mean,
it
she
later
said
this morning, or-
only the offers today, so that's why I'm making sure that he is aware. of what the-
Well, But I want you to have a chance to go with
Right.
it, not at the podium,
Right,
right where he feels the pressure
Right.
of the judge and everybody
Right.
looking at it. I want you to have a chance to think about it, so that if you accept it, you're doing it voluntarily, you don't feel like you're being pushed into it. Do you understand?
Yes, sir.
So, anyway,
Would
let's
you
just
like to
pass
go back
over it
and I'll
and
talk
we'll
to you
come
in a
back.
minute?
Yeah,
Okay,
yeah,
Okay,
please.
all right, go out there and think about it while we.
Matthew Gray.
Casey Etheridge for Matthew Gray, and Your Honor, so we're going to need some more time on this case. We'd be asking if we could have the VOP date after the 30th,
The one after the
the one
30th?
after the 30th, whichever one.
July 7th, 9 a.m. Oh, So the next one isn't until, we got June 15th, June 30th, and July 28th.
I know, well, that's why I was trying to give you time. She
July
said you went to the
28th?
first.
Is that
Yes,
what you
sir.
want?
That's fine.
Okay,
Thank you.
very good.
Yep.
Thank you. Have a good day.
Jeremy Johnson.
Casey Etheridge for Jeremy Johnson. I believe that we're only here on a motion to compel knuckle swabs.
My understanding.
That's correct.
I'm not sure of how procedure over here. We don't usually hear those in Escambia. It's usually just done. So I just
Well,
wonder.
normally it's
what
done,
happened.
but I mean, but
Okay, I just wondered-
technically, you can, you know, the motion was there, and
Okay,
I didn't get it. If you agree and I get an order, I'll sign it. But I didn't get an order, and there was a motion out
Oh,
there, and we would
okay.
need a result.
Okay.
You can, there are bases to object to them.
well, we're
but-
not objecting.
But most of the time, you don't. We all
Right.
understand that,
Yeah.
so.
I was just making sure, I didn't know if there was something in the future I need to do to make sure that, I mean,
Just you communicate.
Okay.
And if the state
Okay.
provides an order and says, with a cover letter that says, the defense is in agreement, and
Mm-hmm.
CC's you to make sure that you really are in agreement,
Okay.
then I'll sign it.
Okay.
I'm good with that.
okay. Thank you.
I trust you all to be communicating with each other.
Thank you. I just want to know the procedure, Your
Yeah,
Honor,
no,
for
good
future.
question. No
Thank-
problem.
Thank you. Just the DNA swab that they'll take.
Just for the record, the court's granting it without opposition. Bradley Koverick. I know there are different procedures.
Yes, yeah, so I was, yeah. Thank you. Casey Etheridge for Bradley Koverick. I don't recall what case number we're here, I think the two VOP.
You're on 21 CF 2021 and 21 CF 3026.
Okay. Okay, so we're asking for some more time on this case, Your Honor. The VOP is based on a new law violation, and I'd like to get depositions set in the new law violation, so we can be ready for a contested hearing, if that's the case.
Okay. How far out do we need to go?
On the 29th right now, for pretrial to go to the law. That's fine.
Just do standard pretrial?
That's fine, Your Honor.
Pretrial, June 29th, 9 a.m.
Right, yep, that's why we're sitting it like that, so we can try to get the depos set.
Jeremy Legrone.
Okay?
All right.
Charles Russell, Public Defender's Office. Judge, this is Jeremy Legrone. Case number is 2018 CF 1353. When I spoke to Mr. Legrone the other day, he said he'd hired private counsel, but I don't see private counsel, so.
Have you hired private counsel, Mr. Legrone?
I don't know what's happened. There's been some miscommunication or something with my family, and so I guess I'm with the Public Defender's Office. I thought that I had.
Okay.
Can we pass this to June 15th?
Let me just say to you, you know, if you get it squared away, you always have a right to substitute a private attorney. So you're not going to be held against
But I
you.
haven't had time to talk to you.
I just don't want you to be here without an
Not right
attorney.
now. Judge, can we put this for June 15th? That'll give me time to go back out to the jail because I didn't talk to him the other day since he said he had private counsel.
Sure.
Can we put it for June 15th at 9, and that'll give me a chance to go talk to him?
And if I could just put Mr. Legron's offer on the record, just so you know, for the 15th, I will leave it open until the 15th if you'd like to take that, but you do score 18 months in prison, and the state's offer, if you'd like to accept on the 15th, is 6 months jail with credit for only your VOP time.
I'll take that right now.
Okay. If you can wait in the back, Judge, I'll go back and talk to him.
Okay. Daniel Lambert.
Charles Russell, Public Defender's Office. Judge, this is Daniel Kevin Lambert. Case number is 20 CF 2296. On Mr. Lambert's case, we've reached a plea agreement. In exchange for a plea of no contest as charged, the state is recommending adjudication withheld, time served, standard court costs, $100 cost of prosecution, $150 PD fee, and 90 days after his release to pay or the money goes to collections, and the state is taking no action on the failure to appear.
Is that the state's agreement?
Yes, Your Honor.
Okay.
Mr. Russell, did you provide a score sheet? Thank you.
Mr. Lambert, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
And is the defense in agreement on the score sheet?
Yes, Your Honor.
So, Mr. Lambert, I'm looking at a plea and sentencing agreement, and we both heard your attorney just state the terms of your plea agreement. Is that what you're agreeing to here today?
Yes, sir.
And have you had a chance to go over this plea agreement with your attorney, make sure you have all your legal questions answered?
Yes, I have.
Okay, you understand that by entering this plea, you're waiving the right to go to a trial, and this will be a final adjudication of this matter. Do you understand that?
Sure, I do.
Okay. And you're entering into this voluntarily? You don't have any further questions of your attorney? Okay. Based upon that, the court will accept your plea, withhold adjudication. You'll get credit for time served, court costs and fees. You have 90 days after you're released to pay, or it goes to collections. And there'll be no action taken on your failure to appear. Very good. Thank you.
Thank you.
Justin Mays.
Judge, this is Justin Mays. Case number is 20 CF 881. Mr. Mays has a violation of probation before the court based on a pending misdemeanor. We currently have a competency evaluation pending, so we'd like to pass the case. We ordered the evaluation back on May 16th, so it's going to be 60 days out. You want to shoot for June 30th?
June 30th is fine. We'll come back June 30th, 9 a.m.
Thank you, Judge.
Thank you. Brandon McGowan.
Judge, my notes indicated no cross was filed in this case.
Okay, very good. Reginald McLean.
Judge, this is 20 CF 2848. Mr. McLean's here on a violation of probation. However, at this time, the state's requesting that the court dismiss the violation of probation and reinstate him to his original terms and conditions of probation.
Very good. I assume there'll be no objection. Huh?
No objection, Judge.
Court will dismiss the VOP at the request of the state. Anthony McManus.
This is 20 CF 3233.
Charles Russell, Public Defender's Office. If I can have a moment, Judge. However you can reach it. Judge, we've reached a plea agreement in this case in exchange for an admission on the violation of probation. The state is recommending an adjudication of guilt, 240 days in the county jail with credit only from his most recent arrest in this case. Prior credit's going to be waived, revoke and terminate his probation, pay $100 cost of prosecution, $150 public defender fee, and he would have 90 days after his release to pay any money owed or go to collections. May I approach?
Yes, ma'am. State in agreement?
Yes, Your Honor.
And is the defense in agreement on the score sheet?
Yes, Your Honor.
Seems to be a slight downward departure. 14.7 minimum,
Yes, sir.
Yes, Your Honor.
based upon?
Agreed upon plea agreement.
Legitimate, of course, please.
Very good. Okay, so, Mr. McManus, just need to ask you a few questions. Did I swear you in?
I don't think so.
Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
I want to make sure you understand what this plea agreement's all about, and it's free and voluntary. You heard your attorney state the terms of the plea agreement, and I'm looking at a written plea agreement that says the same thing. Is that what you're agreeing to? Have you gone over this plea agreement with your attorney? Make sure you had all your legal questions answered. And you understand that by entering into this plea, you're waiving the right to go to a trial. There'll be a final adjudication of all matters involving this.
Yes, sir.
Okay. And you understand, or you believe that there's a factual basis for this plea agreement?
Yes, sir.
Okay. Very good. Based upon that, the court will accept your plea agreement and adjudication of guilt, 240 days in the county jail with credit only from the time of the defendant's most recent arrest in this case. And your probation will be revoked and terminated, so you don't have to deal with that anymore. The fees and costs will go to collections after 90 days. 90 days after release. So you've got 90 days after you get out, not it goes to collections, okay? Any questions? Okay, thank you.
Thank you.
Jalen Mount.
This is 18 CF 1473. Judge, this defendant's here for a violation of probation. The basis of the violation is fraudulent use of a credit card. However, the victim in that case declines to prosecute. The state cannot prove a violation without the participation of the victim. So at this time, the state requests the court dismiss the VOP and reinstate the defendant to his previous terms and conditions of probation.
Very good. Based upon the state's request, the court will dismiss the VOP and reinstate prior probation.
Thank you, Judge.
Okay, thank you. Tracy Ross.
Judge, this is 19 CF 2518.
If I might have a moment, Judge. Charles Russell, Public Defender's Office. Judge, we've reached an agreement on this case in exchange for an admission to the violation of probation. State's recommending an adjudication of guilt, 120 days in the county jail with credit only since her most recent arrest in this case, pay $100 cost of prosecution, $150 public defender fee. Probation is revoked and terminated, and she would have 90 days after her release to pay any money owed, or it would go to collections. May I approach?
You may. Ms. Ross, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Sure.
Is the defense in agreement on the score sheet?
Yes, Your Honor.
And is the state in agreement with this plea agreement as stated?
Yes, Your Honor, and the 4 months is for this VOP credit only.
Credit for time served since the most recent arrest. Okay. That's the way it's stated in the plea agreement.
Yes.
Okay. So, Ms. Ross, you heard your attorney state the terms of the plea agreement. I'm looking at the writing, it says the same thing, and I see that you've signed the back of this. So, main thing I want to make sure you understand, you've gone over this with your attorney. Make sure you had all your legal questions answered. Have you done that? And you feel like you understand what's going on with this legal? Nobody's coercing you or pushing you into this plea agreement?
No, sir.
And you understand that by entering this plea agreement here today, it'll be a final adjudication of this matter. Be an adjudication of guilt, 120 days, not going to a trial. This is the final resolution of this matter. Do you understand that? Okay. And do you feel like you've gotten good representation on this?
Yes, sir.
Everybody clear? Bless you. Okay. Very good. Based upon that, the court will accept your plea agreement as stated here, be an adjudication of guilt. 120 days in the county jail, you'll get credit for time served, but only since the most recent arrest. And all the fees and costs, you'll have 90 days after your release, and if it goes to collections, and probation will be revoked and terminated, so you don't have to deal with that anymore. Okay. Any questions? Okay. Thank you very much.
Thank you.
Curtis Simmons.
Charles Russell, Public Defender's Office. Judge, this is Curtis Simmons. Case number is 21 CF 3258. This is here on a violation of probation. We have a pending competency evaluation on Mr. Simmons, so that was just ordered on May 20th, so could we get a date in July, probably?
July 7th or 28th?
Let me go to the 28th, and if we get it done earlier, we'll schedule it for
Very
earlier.
good. July 28th, 9 a.m.
Thank you, Judge.
Jerry Simmons.
This is 19 CF 801.
Charles Russell, Public Defender's Office. Judge, if I could have a moment. Mr. Simmons' case, Judge, in exchange for an admission to the violation of probation, the state is recommending an adjudication of guilt, 270 days in the county jail, but the parties stipulate and agree that the defendant has served that sentence, pay $100 cost of prosecution, $101.83 to the Okaloosa County Sheriff's Department for the cost of transportation, pay $150 PD fee, probation is revoked and terminated, and then he would have 90 days after his release to pay, or the money would go to collections. May I approach?
You may. Is that stated in agreement?
Yes, Your Honor.
And the defense in agreement on the score sheet?
Yes, Your Honor.
So, Mr. Simmons, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? You heard your attorney state the terms of your plea agreement, and I'm seeing that that same plea agreement is written out on your written plea and sentencing agreement.
Yes, sir.
Have you gone over both these, have you gone over this with your attorney, your plea and sentencing agreement? Make sure you understand what this all means from a legal standpoint. You had all your legal questions answered.
Sir.
You understand that by entering this plea agreement here today, you're waiving the right to go to a trial.
Sir.
And this will be a final adjudication of this matter. You'll have it totally resolved. You understand that? So, based upon that, and you're entering this freely and voluntarily after kind of understanding what it's all about?
Yes, sir.
Okay. Based upon that, the court will adjudicate guilty, 270 days in the county jail, and with the understanding and the stipulation in writing that you've already served this 270 days. So you'll get credit for time served, but it's in excess of the 270 days. You'll have some costs and fees that you'll have 90 days after your release to pay. If not, it goes to collections. Okay, is that your understanding of everything? And that's what the court's sentencing you to, and good luck.
Thank you.
Stephen Steele.
Charles Russell, Public Defender's Office. Judge, this is case number 20 CF 331. At this time, Judge, we'd ask to pass it to the June the 30th without subpoena, so I can talk some more to Mr. Steele, and then after that, we'll be ready to set it for a contested hearing if we can't
Very
work it
good.
out.
June 30th, 9 a.m. Tristan's, I'm sorry?
Say something.
Just mention it to your attorney. I don't want you to say something that might hurt your case. I'm not involved with whatever negotiations. What my role here today is to make sure that everything is, if you enter into a plea agreement, it's free and voluntary, and if necessary, we go to a hearing. So I can't kind of get in the middle of your negotiations.
For the bond here.
Yes, I'm going to work on that too.
Kristen Stewart?
Eighteen CF 977.
Charles Russell Public Defender's Office. Mr. Stewart also has a case on this afternoon's docket. For the clerk, it's 22 CF 1297. It's set for felony plea. Oh, I'm sorry, it's not on this afternoon's docket. The new case, 22 CF 1297, is actually set for June the 30th at 1:30 for a felony plea day. So the state's already filed an information in that case. What we would propose to do is pass the VOP that's set for today, enter denial, and pass it to June 30th to go with the new law violation. And then, because the state's made an offer, but I haven't had a chance to talk to Mr. Stewart about it, we might be able to resolve it on the 30th.
Very good. So the court will enter a denial on the VOP. We'll come back on June 30th at 9 a.m.
It's actually...
Oh, it's at 1:30.
1:30, yes, sir.
Okay. We'll do it at the same time as the other one. Okay, thank you. Whitman?
Charles
I know
Russell.
that there was...
I can explain some of this, Judge.
I know.
Charles Russell Public Defender's Office, Somchai Whitman, 2017 CF 3017. So Mr. Whitman is in the state hospital or in a facility run by them. The case was set for a status hearing by us today because we got some reports from the state hospital. He's still incompetent, et cetera. The court signed an order and set it for the review hearing for today. I would just ask that the court maybe issue an amended order that puts it off. I think they say they want to review every year, so I don't know if you have your calendar for next year yet, but we just ask that the next review hearing be set sometime next year.
I agree, but I think we do have if you'll just check, we do have our preliminary calendars.
Okay.
It'll be, I think Judge Gonteric will be running the same calendar, so I think we can go ahead and do it, but just check with my office.
Okay.
To try to go ahead and get it on there. I agree with you, you always want to have a date. You don't want people to get lost in the system, in the state, not have some review and whatnot. I
Okay.
did review the forensic report, the updated one. State have anything to add?
The only thing I would recommend is us just setting it for a 6-month status review. That way in 6 months, we'll have.
Is it 6 months or a year that we need to, I thought it was 6 months.
I typically request 6 months. I think that's,
Okay, I agree, 6 months, but
That's fine.
can I don't know what,
Yeah, what,
that's December, so we got
Ma-
December.
Madam Clerk.
What do we have in December for a? Yeah.
You have the 1st, the 8th.
We'll do the 8th.
that's fine. And that's at 9, Judge?
Yes. Okay, so do we have we've got a few that we passed over. Do we want to try and,
I have one lady that showed up late, Judge.
okay?
May call her.
You may.
Anita Smith, she's number 12 on your docket. Case number for the record is 21 CF 2096. This is here on a violation of probation. Ms. Smith was coming from Panama City, and that's why she's late. The court had issued a no bond capias. We'd asked that the capias be withdrawn and set it for June the 30th to give me a chance to talk to her.
No objection.
Now, be careful, ma'am. You gotta get here on time. I don't want,
Yes, sir.
nobody wants to be picking people up because they don't show up for court, but that's what we have to do if you don't do
Even with a
that.
likely story?
No, you don't have to tell me, but I'm just saying,
No, thank you, sir, and I will.
we don't want to be doing that.
Right.
Okay, thank you. June 30th and 9 a.m.
Gotcha.
Okay?
Thank you, Judge.
Jake Bell, Miss, or do you want to do another one? Miss Etheridge?
Yes, Your Honor, we're ready.
You want to do Bell?
Yes, that's fine.
Okay.
Casey Etheridge for Jake Bell, and we're here in 2021 CF 2377, and he would like to admit to the allegations in the affidavit and accept the state's offer. And Your Honor, the offer is for adjudication withheld, revoke and terminate probation, 180 days in county jail with credit for all time served, $100 cost of prosecution, $150 public defender fees, all fines, fees, and costs reduced to judgment.
In agreement?
That's correct, Your Honor.
May I approach?
May. Defense in agreement on the score sheet?
Yes, Your Honor.
Thank you.
Questions?
I think you need to do a little more filling out on the score sheet. Just look at it. I just don't see the computation. Maybe I'm missing something. Mr. Bell, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay, so you just heard your attorney state the terms of your plea agreement, and I'm looking at the plea, a written plea and sentencing agreement says the same thing. Is that what you're agreeing to here today?
Yes, sir.
You had a chance to go over this plea agreement with your attorney to make sure you get all your legal questions answered?
Yes, sir.
And is you entering this freely and voluntarily after kind of knowing what's going on here?
Yes, sir.
And you understand that by entering into this plea agreement, you're waiving the right to go to a trial. This will be a final adjudication, be much more difficult to appeal it. You understand all that?
Yes, sir.
Gone over that with your attorney. Okay, and the core of this, obviously, is the 180 days in the county jail, credit for time served. Your probation will be revoked and terminated, done, finished. There will be, and continue to have an adjudication withheld. That's your understanding of all this?
Yes, sir.
You'll have fees and costs will be reduced to a judgment. Okay?
Yes, sir.
Very good.
Thank you.
Court will accept your plea and sentence you to the 180 days with credit for time served and revoke and terminate supervision.
Thank you.
Probation. Okay, thank you.
There is no score sheet, Your Honor. It's a misdemeanor. It's
Okay,
a misdemeanor case.
okay. You got to confuse me. Okay. Is that you have any other ones?
Yes, so Robert Cannon,
Right, Cannon, there you go.
and we're here in 2020 CF 766, 2020 CF 2508, and 2022 CF 1260. Mr. Cannon would like to admit to the allegations in the affidavit and as well as enter a no contest plea to the new law violation in 2022 1260.
You get take that one, no?
I wish they had a pass-through in the back, Your Honor, because then I could just put it under there and have them sign it back there. I wish they had a pass-through in the back.
Or you don't have pass-through?
No, I don't have a pass-through, so I can't have them sign it while they're back there.
So have you made that suggestion for the new courthouse in Santa Rosa to make sure that they do that when they build
I
it?
have not, but I will.
You need to. Obviously, the architects didn't speak to the attorneys. We found a lot of little small things. It's amazing the degree of complexity in these courthouses and multiple meetings trying to just do all this kind of stuff of where things are placed and how, and still constantly, anyway, I'm sorry.
No, you're fine. And so the offer that Mr. Cannon's accepting is adjudication of guilt on both violation of probation cases, reinstating probation and modifying to 24 months of community control. Okay, and it's the cost of supervision will be waived, $100 cost of prosecution in each case, $150 public defender fees in each case, and mental health evaluation, any recommended treatment, and stay away from all Walmarts, and 8 hours of community service work per month. And then the new law case, the 2022 CF 1260, is adjudication of guilt, 24 months community control concurrent with the VOP cases. The cost of supervision is waived, $415 in court costs, $100 cost of prosecution, and $100 public defender fee. May I approach?
Before you do that,
Sure.
Mr. Cannon?
Yes, sir.
You seem to be looking at your defense counsel with some question in your face. I just want to make sure, is that your understanding of what all the plea agreement is? Did you have a question? You looked like you weren't quite clear about something. That's my job here, is make sure you understand what you're entering into. We're not trying to railroad you here. Did you have a question? You're welcome to, you can do it off the radio if you have a question. I just want to make sure you have all your questions answered from your attorney.
Yeah. Yep. No. Not unless you create them yourself. Yep. Would you like to accept the offer?
Yes.
Okay, well, he needs to hear you say it.
Okay,
Yes, sir, I understand, and
I'll ask you some specific questions. Mr. Cannon, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
yes, sir.
Okay, and state's in agreement?
Yes, sure.
And the score sheet, the defense is in agreement?
Yes.
Okay, so, Mr. Cannon, I'm looking at your score sheet, not your score sheet, the plea and sentencing agreement, as well as, I just listened to your attorney state the terms of the plea agreement. Is that your understanding of what the plea agreement is? The core of it is the 24 months of community control, right?
sir.
All those, on all three, the 2 violations of probation as well as the new law charges.
sir.
All be served concurrent. They're not stacking them on top of each other, all at the same time, 24 months community control, right?
Yes, sir.
Do you understand? You've had it explained to you, all the higher levels of supervision, the community control, not a walk in the park. Have you had all that explained to you, the difference between probation, community control?
Yes, sir, I know yes, sir.
Okay, and you're willing to do that. I want you to be successful. We don't want you to have to come back in here, because the way it works, if you have, I'm sure you figured this out. You have probation, community control. The next step is not one you want. So we want you to stop here, seriously.
I am.
So we just want to make sure you're clear about what you have to do. And the most important thing, in my view, of the whole thing, it's silly. Stay in good contact with your probation officer.
Yes, sir. Yes, sir.
That's your start point, really.
Yes, sir.
Some people don't do that, and it's like, what are you thinking?
Yes,
See, pick up the phone. Everyone's got a cell phone.
Yes, sir.
Talk to them, okay?
Yes, sir.
Stay in touch.
Yes, sir.
So, you got a bunch of fees and costs. All those are, now, on the fees and costs, those will be during the term of the community control, so you'll be able to pay those over time. Make sure you stay away from Walmarts. If you haven't figured out, Walmart's is the most sophisticated video system in the world. So don't go around Walmart because you'll be on camera and you'll violate this probation, okay?
Yes,
Figure
sir.
out some way, whatever. I know they got a bunch of stuff in there to buy, but just stay away, okay?
Yes, sir.
Okay. Very good. So, you understand that by entering this plea and sentencing agreement, that you are,
You need the offense date.
waiving the right to go to a trial and the final adjudication of all this.
Yes, sir.
Based upon that, the court will enter. Now, I think you need to, there might be a couple things here that need to be filled out. The adjudication, withheld, adjudicated, guilty, not contest.
Apologize, I put it at the
That's
bottom,
all right.
so I didn't-
There's a bunch of stuff to fill out, I know. I appreciate you typing it out and all that. It makes it a lot easier. Yes, sir.
From a probation standpoint, let me start out by saying, I know Mr. Cannon.
Okay?
If we could take the charge that he's on probation for now, which is a petty theft, third or subsequent, reinstate him to that period with the remaining period on community control, that would take care of that. And then give him 2 years on the new charge. He's on probation on that charge till November the 30th of 2023.
Either way works fine.
It's still going to be 2 years community control. One's going to finish quicker than the other.
Well, as long as we make sure we clarify it and he understands it. Do you understand what Mr. Berry is suggesting?
Okay, because I mean, what we have on there is that we're reinstating and modifying it to be community control.
Then we're going to have to go in our, remember the old
Okay.
DOS system and try to push that date out? So
Oh,
if we
just
can
the
just reinstate that
Okay.
portion of the sentence.
Okay, so
With the
remaining.
remaining period on community control.
Okay.
I want to just let the court know it's going to be very tough to get Mr. Cannon somewhere to do community service work due to the fact that obviously he likes to take stuff that does not belong to him. I don't know
You're going to have a hard time.
who's going to allow him to do community control. Definitely not Walmart. And I know Mr. Cannon's living situations are not stable, and I think the word house arrest would be best said to Mr. Cannon.
Right.
Are you going to have somewhere to stay? Homelessness is not a violation, I just want you to know. But, do you have anywhere to stay?
Mr. Cannon, what he's saying is when you talk about community control, and actually they ought to use the term, house arrest is a better term. Because essentially, except for going out for jobs and whatnot, you got to stay at the house under community control. That's why I was asking you, do you understand what that all means? And, because it's pretty onerous, quite frankly. I'm not shortcutting it, but I just want to make sure you understand what all you're doing. What about so you do understand about the community control and the house, essentially house arrest? Do you understand? You've had all that explained to you?
Yes, sir.
In your honor, the state made several different offers for him to choose from, and this is what he has chosen.
Okay.
One of them county jail sentence?
Yes, it was.
No, it was 12.1 months state prison.
Sorry.
Okay, so the 8 hours of community control, not community control, yeah, of community service hours
Yes,
per
sir.
month?
If you don't think he'll be able to find anywhere, then we can delete that.
I mean, we don't want to, we won't want to set him up for failure. That's not what we're trying to do here.
I mean, the majority of the places we stand is Goodwill, Waterfront Mission, Exodus program, thrift stores like that.
And they won't do it because
I'm
of.
not saying they won't. We're going to, I don't know, it's going to be difficult for him to try to convince them to let.
Is there any way we can do it and then delete it if we can't get it done? How would we word that? Why don't we just waive it? Court's going to waive the, the community service requirements. Okay. Very good. Good luck, Mr. Cannon.
Sure, thank you.
Stay in good contact with your probation officer. Come talk to him.
And then I have one more, probably gonna totally butcher this. Dylan Zakowski, I believe is, the D is silent, he tells me.
Can I ask you, I'm sorry, you've had to change this several times, but that's on the community's service hours. Yeah, just scratch through it. Thank you. Oops, sorry.
Casey Etheridge from Mr. Zakowski, we're here on 2020 CF 1378, and he would like to admit to the allegations and accept the state's offer of 180 days in county jail. It's adjudication of guilt, revoke and terminate 180 days county jail with credit for all time served, $100 cost of prosecution, $150 public defender fees, and all fees, fines, and court costs reduced to judgment.
Your Honor, there was $134.97 cost of transportation and.
Is that on there, Miss Etheridge?
I know, but I can put it on there. How much was it?
$134.97.
How do you pronounce your last name, sir?
Dikowski.
Dikowski? That's not as hard as it looks.
Right.
Mr. Dikowski, would you raise your right hand? And let me swear you. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
You just heard your attorney state the terms of your plea agreement, and that is adjudication of guilt, revoke and terminate probation, and then you have 180 days county jail, credit for time served. That's basically the core, all the fees and costs reduced to judgment in addition, and is the 134.97 restitution?
No, Your Honor, it is cost of transportation. The
Okay, I thought it
sheriff's
was-
office seeks
Well, it is
reimbursement.
Is that technically restitution?
I mean, that's how I've been understood, but I can change it.
No, that's all right,
Term.
but as long as you're good with it. We're just trying to tighten everything up. My job is to make sure everything's clear, so that, because, this is obviously impacting you, it's important to you. And we want to make sure that you understand what it is, and we understand, and everything's written down, so that everybody's clear. So, is what I just explained to you, and is that what you've agreed to? Do you have any questions about that?
Yes. After my sentence, I have to pay those fees, the 134 and the 100.
And it'll be reduced to judgment, so it'll go to judgment. You're not going to violating, you're not going to be put in jail for not to pay it, but it'll be a judgment, which is a lien,
Okay,
like any other debt you'd have.
gotcha. Okay,
Is that your understanding? Is that you in agreement with that?
yes, sir.
You understand that by entering this plea agreement, you're waiving the right to go to a trial, and, this is a final resolution to all these matters. Do you understand that? And I know we came back here, if you had a chance to go over this with your attorney, make sure you understand what this means to you legally.
Yes.
Any questions?
Nope.
You've entered into this freely and voluntarily. Nobody threatened you or promised you anything that's not in this agreement?
Yes.
So you've entered it freely and voluntarily.
Yes.
Very good. Based upon that, the court will accept your plea agreement, order an adjudication of guilt, revoke and terminate probation, sentence you at 180 days in the county jail, credit for time served, fees and costs will go to judgment, in addition to the cost of transportation or restitution in amount of 134.97. Okay. Good luck. Is that our last case?
Yes, sir. Can we recall Jeremy LaGrone?
Okay.
Case number is 2018 CF 1353.
What number
I
is?
believe we have an agreement, Judge, if I can have a moment.
Sure.
Judge, on Mr. LaGrone's case, in exchange for an admission, the state is recommending an adjudication of guilt, 180 days in the county jail, but he's only going to receive credit since his most recent arrest in this case. He would pay $100 cost of prosecution, $150 PD fee. His probation would be revoked and terminated, and he would have 90 days after his release to pay, or the money would go to collections. May I approach?
This is an uncoerced downward departure, Judge.
Very good. And the state's in agreement?
Yes, sir.
And the defense is in agreement as to the score sheet?
Correct, Judge.
Okay, Mr. LaGrone, would you please raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth, and nothing but the truth, so help you God? You hear what the state said about the downward departure, you know what they meant?
Yes, sir.
And so the score sheet has a minimum sentence of 18.15 months. Obviously, you're agreeing to something less than that based upon the agreement with the state. You understand that? And you understand that based upon what your attorney just said, as well as what's in the plea and sentencing agreement, have you gone over all that, all these details? Make sure you understand what the legal ramifications are of all this? You had all your legal questions answered by your attorney?
Yes, sir.
And do you feel like this has been entered into freely and voluntarily? Okay. You understand that by entering into this plea agreement, the court's going to sentence you here today, and this will be a final resolution of your case. You're not coming back for any trial. It's being resolved. Do you understand that? Okay. Very good. Based upon that testimony, the court will accept your plea agreement. There'll be an adjudication of guilt, 180 days in the county jail, credit for time served, and your probation will be revoked and terminated. You don't have to worry about that anymore, okay? And all the costs will go to collections 90 days after you get out. So you got 90 days to pay it after you get out of jail, and then it goes to judgment, okay? Any questions? Okay. Thank you very much. Did I forget something? Is that our day? Okay. Would you all step forward here? I just want to ask you, this is a scheduling issue.